We dialed him back. There were like two other big chunks that.
Ryan,
Hey,
Steph Dexter.
Yeah,
Nice to
we
meet
didn't have
you.
the money for it.
How you doing?
So we
Kevin
pulled
Foley.
out
Good to meet you.
Caesar, we know you.
on the others.
Yes.
And then-
No need to get up.
But, we said that we'd come back to it after this, because we didn't know if this would pass.
Yeah, welcome, everybody.
You're our chair tonight, as the vice chair, right? No,
No.
you're the vice chair.
Yeah,
You have to
Oh,
start
temporary
out.
chair.
Alrighty then.
You have to-
Well,
right now you're the boss.
You're the boss. guy.
Wayne's out of town, but I think
Wait a
everyone
minute.
else is here.
are we waiting on some, who are we waiting on, Wayne?
Wayne's not coming.
He's not coming. Okay.
Is it seven?
Chief would still be
Yep.
sitting
Seven.
until he's replaced, if I understand the rules, right? The chief would be sitting until he's replaced.
A tea?
Is there
I'm sorry.
anyone,
You're usually over here.
I was gonna say like.
is there anyone
switched
for,
up.
I
You
don't
talking
think there's
about
anyone for a
Tifo?
chief to sit for.
Okay, I'm sorry, I
Sincere.
apologize.
Jesus.
Don't mind me.
Hold on, folks. Alright. I thought Paul was running the whole show here. My God.
You have the agenda?
Alright, we got my agenda. Alright. We'll call to order, meeting for Tuesday, November 18th. First call to order, is pledge allegiance.
To the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Alright, if everybody could turn their phones to silent. Alright, so minutes from the, call to order. Meeting, there's nothing to, read out. So the minutes from 10:28, has everybody reviewed? Except by consensus?
Yeah.
All those in favor say aye.
Aye.
Opposed? Alright, we're good. Alright, new business, discussion, decision, and act regarding the following. Annual organizational meetings. A, election of officers. Review of the bylaws and review of the 2026 meeting dates. Let's start off with election of officers. Floor is yours.
Thank you, Mr. Foley. I would like to nominate Paul Bernstein for the chair of the Planning and Zoning Commission.
Can I second?
Second?
All those in favor, or is there any other nominations?
Oh, yeah.
Are there any other nominations? Seeing none? All those in favor?
Aye.
Opposed? Alright,
Vice Chair now?
Vice Chair.
I'd like to make a nomination to nominate Kevin Foley as our Vice Chair.
Second.
Second.
All those in favor?
Aye.
Aye.
Oh, hold on.
Oh, any other
Paul
nominations?
is running the show.
Yeah, oh yeah, that's
Oh,
right.
now
Now
Paul.
you,
Oh,
dude,
yes.
baton is yours. Alright,
I'm wearing the mask because I'm dealing with a serious sinus cold, so please bear with me. Any other nominations for vice chair? Any other nominations for vice chair? Any other nominations for vice chair? All in favor of Kevin Foley for vice chair? Say aye.
Aye.
Any nays? Abstentions? Would someone please nominate someone for secretary, the only other?
Yes. I'd like to nominate Cesar Lopez.
I'd like to nominate,
oh, we'll go through that first.
Any other nominations?
I'd like to nominate Stephanie Dexter.
Any other nominations? Any other nominations? Any other nominations? Those in favor of Caesar for secretary, say aye. Aye. For Stephanie?
Aye.
Aye.
You.
I can't, I'm an
you can't
alternate.
vote, no, right, that's correct, right?
No,
I'm
you're
not
not
here.
voting.
Josh, can we do a roll call?
Okay. I think I have my sheet back here. Commissioner Capuchinos. Stephanie Dexter. Commissioner Dexter.
I'll vote for myself.
Commissioner Abrahamson,
Cesar Lopez.
Commissioner Foley,
Stephanie Dexter.
Commissioner Lopez,
Lopez.
Commissioner Welch,
Cesar Lopez?
Chair Bernstein.
Cesar Lopez?
Right. Commissioner Lopez, you voted for Commissioner Lopez, right? Yeah. Okay, so that is 4 in favor of Cesar Lopez, 3 in favor of Stephanie Dexter.
Congratulations.
Thank you.
Any other business relative to elections? Then we shall move on to review of bylaws. Does anyone have any issues related to the bylaws that they would like to bring forward?
I know we did some changes to these 2 years ago. Steve went through and did a good review and,
Yeah, you moved your minutes around, you know, you moved your agenda.
Yep,
a little bit.
yep. If anything.
Revised from December 25th.
So on most things, normally the chair is the last to speak, but I have some things that I'd like to bring forward. A couple of them pretty minor. And by the way, and I don't know who can best address this, I don't know if it's our legal counsel or Michelle. There's a number of things that I looked into and I found myself playing a shell game. The bylaws in some cases refer to the Connecticut general statutes, and then the Connecticut general statutes refer back to things like town ordinances and charters and so forth. So in some of these things I'm going to bring up, I don't know where the thing I want to do rests, so maybe you can guide me. So the first thing is Article 4, meetings, and this is just a minor thing, but it's my understanding that the agenda for meetings is set up by the chair and,
Article 9, right? On page 3, Article 9? Yeah. okay.
yeah, I'm
Me,
sorry.
yeah.
9, meetings. The meeting agenda is established between the chair and the director of planning. I think the first sentence should call that out. So add that sentence, unless that resides somewhere else.
Paul, what wording, do you have some wording, draft wording you're thinking?
Meeting agenda is established by the director of planning and PZC chair.
What I would suggest is meeting agenda is established by the chair with consultation with the director of planning or.
That's fine.
Something like that, because I don't really think that the planning
That's
should
fine.
have such
Yeah.
a primary role, but, okay.
Excuse me, I don't know why I don't see that. This is Article 9 meetings,
Yes.
This
page
is wording
3.
he's suggesting under what,
He's
item 1.
adding.
Oh,
Adding to item
Just
1.
I'm just adding that
I get it.
sentence to begin with. So the rest of that section references adding things to an agenda. And in most cases, I imagine it has to be done, according to this, 6 days prior to the regular meeting. I think we've had situations where items have been added just prior to meetings, and there really isn't any language in here that calls that out. So something like to add an item to the agenda prior to the start of a regular meeting, a motion must be made to amend the agenda. Before the change is adopted, a simple majority vote is needed to add the new item. Does that make sense?
It does make sense, but what if there is a deadline to be followed by the statute for a particular application that comes in?
Give me an example, because
Something that needs to be approved by a particular date.
That would have already been established, somebody would have already, if there's a deadline, they
So,
would
you
have.
know, so just so we always carry on your agenda, your page 2 is the pending applications that are always carried as agenda items. So you could in theory take that up as part of the agenda item. I think what you're talking about, if something's not on the agenda, you wanna add it to the agenda.
Yes.
My understanding was always a regular meeting, you could add things to the agenda. It usually happens, I suppose at the beginning, it usually happens during the course of the meeting, but I suppose you could do it at the beginning of the, we don't approve agendas like the town council does, a little bit different format that we have here, so.
If you have a discussion item on something that you wanna talk about at a meeting, and you haven't really, something's come up maybe in town, and you say, oh, we should really talk about that tomorrow night, and you wanna put that on the agenda, that's just a simple majority, and you amend the agenda at the start of the meeting. I don't think you can add an application, right? Or
No, so, I
and
mean,
then you're talking
you-
about like something that you have to act on, and if you wanna talk about something, that's fine, but.
Yeah, and we've done that. There have been cases where something has come up and,
And you can add things to a standing regular meeting agenda by simple majority vote. You cannot add items for discussion at a special meeting. If you had a special meeting for a particular purpose, you're stuck with whatever that purpose is.
So to your point, we could add a sentence like that in this paragraph, items can be added to a regular meeting by a majority vote.
can you help me with that?
Sure.
All right.
I'll draft some.
So another thing, and this really has more to do with the issue about the shell game that I referenced. There's nothing in the bylaws that talks about removing an officer. And there is something in the statutes, but it's vague and it refers back to, I'm not familiar with like our town charter or ordinances. And I think it refers back to that. So it feels on one hand like it's something that doesn't belong in the bylaws, but I don't know, there should be some language somewhere that relates to the ability or opportunity, or call it what you will, to recall or remove an officer.
You wanna refer back to the charter or your enabling ordinance. Is that what you're saying?
If it's there,
It is, yeah.
Okay.
Yeah, there's sections in the charter that talk about the maximum number of people on planning and zoning commission from any one political committee. And then there's also your enabling ordinance, which I've never seen anywhere but here, is that you cannot have as a sitting member a real estate agent or broker or insurance agent or broker. So are any of you real estate agents or insurance agents? Good.
No.
Because your ordinance says you can't sit on the planning and zoning commission if you're an insurance agent or broker or a real estate agent or broker. And so I think that's whatever the reading
Take that out.
is referring to.
I think
perhaps.
what he's trying to get at is if we decide we don't like Paul as our chair, how does the commission vote
yeah,
to
or
take
let's,
him out of a chairmanship?
let's say as
Is
chair,
there a
I'm
mechanism for
not
that?
making many meetings, I'm making, 2 or 3 meetings out of 10, and you'll say, this doesn't work, we don't have an effective chair, we need to change the chair. What's the mechanism for making that happen?
I thought the ethics commission, because, it's an elected body, but I don't know if there's another way.
Well, yeah, you can't, the whole idea of having alternates and a vice chair is that the inability of one particular person, like the chairman, to not be able to attend for whatever reason, means that this business still continues. You have alternates that can get seated, you have a vice chair that can take your role. If at some point you want to resign your your position as chair, you can just say that, and you can have another set of elections like you did tonight. Just say, okay, who's gonna fill that slot? But you can't, unless you resign your position as an elected official, in which case the town council fills the vacancy, I believe. That's different than what you're talking about.
Yeah. Mr. Sorrell, suppose we just become unhappy with Paul's rulings, and we say we don't want him to serve as chair anymore.
I don't make rulings.
Yeah, it doesn't make rulings, and I don't know that you can really, I don't know
This
that
is-
you can
understand
really
what I'm
do that.
saying.
I think
This
you-
is a no
I didn't
king's
think you could
commission.
put anything in your
Yeah,
bylaws
you
for
can't,
that.
you really, there's no real ability to do that. You just voted Paul, for better or for worse, until the next election, or until he steps aside as chairman to be the chairman. And you have a vice chairman, right, Mr. Foley, right? And then you have other officers, that can step and fill into these roles if they, for some reason, can't do it. When I say can't do it, I mean, just not aren't here, you know? Pass away or get hit by a bus or resign or move out of town, you can no longer be on the commission, then that's different. Then the town council's gonna fill your seat, and there'll probably be another election of officers to fill the leadership position. But you just can't get rid of him because you don't like the way he's acting, at least not.
So, not to belabor it, so what I think I'm hearing is there is language, it may not exist in our bylaws, but there is a mechanism to remove or recall an officer in other documentation.
Sounds like there's none.
I don't know that there is.
But
I mean,
your
maybe the
ethics
commission?
your ethics commission could look at somebody's behavior and remove them.
You gotta take a look at it. I know the town council talked about,
Be the closest I would come.
people participating and not showing up for meetings, and I think there might be something in there that says if you fail to show up for
So-
meetings, it might be in there, but I can take a look at that.
I Googled this and I got a hit. Goshen in their bylaws has one sentence that says, members of and alternates to the Planning and Zoning Commission may be removed for the unexpired portion of their terms by a majority vote of the Board of Selectmen, but only after good cause shall have been established.
They're probably
we have
appointed
that.
by the
That's
selectmen. I'm
probably
guessing.
appointed. Yeah, you can't, you're all elected, right? You ran for
Well,
office.
the alternate, it's Article 5 that addresses if I don't show up if more than 50% of the time, you can replace me. Alternates.
Okay.
Alternates, yeah.
Okay.
Well,
You're it, Paul, sorry.
All right, I'm gonna move on.
So those are the only two changes that you want me to draft then?
Well, I have two other things I wanna bring up, and I don't, because I have the floor here, I don't know if these are bylaws related, but to me, they're discussion items, and one of them, my next item, has exactly to do with what I just said, which is, this has been a frustration of mine. I understand we're a commission, I understand there's a public notice role in what we do, I understand we have to be transparent. It's kind of frustrated me that we as a commission have very, very little opportunity to discuss amongst ourselves issues related to what we do. And that might be a conflict in some way, shape, or form, but it doesn't have to be. I mean, I think we can get together and discuss things without there being any issue, concern, bias, or what have you.
You mean in the
Well, that
public or not in the public?
Off the record, or?
Yes, like in executive session.
No, that-
that's, all right, so.
No.
I guess a lot of it depends on what you're trying to discuss. Like, if you wanted to discuss the bylaws, or, I don't know, there's new housing laws, some sort of discussion, or something like we're doing tonight, right? This is done in an open public meeting. It's technically open to the public. Minutes are taken, there's a recording of this. That has to be done in an open meeting, because there's more than a quorum of you, and you're engaged in the agency's business. Is that what you're talking about? Or are you talking about you wanna get together at your house and have pizza and
No,
wine
no,
and
no,
talk about
nothing,
this stuff? Okay,
nothing like
fine.
that. I understand
That
that.
you can't do, right,
Right.
okay. So what are you trying to,
Something more along the lines of what we're doing now,
right?
although this is public, right?
Oh, yeah.
Yeah. And it can be public. I'm not saying it has to be. I'm just saying that we as a commission, seems to me, have very little opportunity to discuss, consider, things related to the town.
Like,
Other than, go ahead.
And maybe, so if there's a member of our commission who already has a predetermined, like, every application that comes in, it's steadfast, you wanna be able to go behind closed doors and go, you can't do that, right? Or,
I guess the best example I can come up with is, we do this when we're putting together our planning zoning, plan of conservation development. We work together.
Workshops, right?
Yeah, it's workshops, and that's really the kind of thing that I'm speaking more of would be workshops. Things along those lines, and
Spitballing.
Working sessions.
A working session, it could still be done in a meeting like this, like we're doing tonight, in an open meeting. You can have an open discussion about it. And I think you'd probably want to identify with Michelle or whoever what the topic is. So if it's a topic about, you know, affordable housing or, you know, whatever the topic is that you want some background on or some education on, or what's the latest, you know, there's just a bill that just got passed on Wednesday last week or Thursday last week that needs to, we were just talking about it. We have to get up to speed on it. And then we gotta talk to you all about it. So there's things that are going on out there that you need to be apprised of, and is that what you're getting at? Like, you wanna have the ability to spitball that amongst the group and talk about these
something
things?
more along those lines.
Yeah.
And,
You can put an agenda item to get, as part of your setting the agenda with the director, you know, you might say to her, okay, I heard that this bill got passed the other night. Are we able to talk about that? Do you have any thoughts or recommendations? And she'll tell you, we're all waiting on some review.
But there's no opportunity to do that like a workshop without the TV screen being on.
Not if more than 4 of you are getting together.
Right, not if there's a quorum present. That's right.
And you know, the other thing we run into too, quite frankly, is you have things pending quite often, and it's hard to have
Right.
general discussions about things that are pending and you're gonna opine about, right? So some of that does deter us, but, you know, in opportunities where we don't have things pending and you want certain topics, you know, we talk about different topics all the time when we are changing regulations and things like that. We certainly can get more into any topic you want, Paul. But based on my conversation with you, I think some of what you're thinking is that you can do some of this in executive session, and the answer is you can't. There's very limited times we can go into executive session, as many of us have learned over the years.
so given the tenor of this, what I would opt to do is just table it, and if an issue comes up, I discuss it with you, we put it on the
How best to go
agenda,
about it. Yep.
and there it goes. I'm not the only one I know that has had a frustration about this, so any other commissioners that want to chime in on this, you know, please feel free to do so. I just wanted to kind of open the box to, you know, getting this issue out there, and I'm pretty comfortable now with what I think has to happen.
I think just to add a little bit to that, I've been frustrated when handouts have been given us for an item on the agenda that night. And I think that we all may agree, we all like to be prepared and read through these things before we get here. So I don't know if there's
So
some
I have an
control on
interesting
that.
question for you, Rich, on that. So tonight you guys are gonna take with you a packet that just came in for the big project that's pending, because it's a lot of data, it's traffic studies and all that kind of stuff. You know, public hearing's not open on that, so I always worry that people are gonna take this information, do something with it before the opening of the public hearing, and sometimes that's why applicants don't wanna give you things until the public hearing. I think if that's when they do it, you have every right to keep a public hearing open if you have not had adequate time to review things. I mean, you should for those reasons. So I have different folks that approach it differently. To me, you wanna get this information ahead of time so you have some time to take a look at it.
I'm with Stephanie on that.
We give you what we can, trust me, ahead of time.
You
Then we
give
have-
us, in our packets, when it gets mailed to us, it gives us the chance to look, review, read, go visit sites,
Sure.
do our homework, and then when we sit down, we're getting ready to start the meeting, next you know, you guys are handing out, it's like, oh, what the hell is this? Like, it's, now we don't have time, and it's little tiny prints that
Michelle's
we
right,
can't
but you
read.
keep that public hearing open until the next meeting, so digest what the applicant has
But
given you the night of.
As you know, like, we've had more than one occasion where it starts, it's like a train wreck. We start
Getting behind, yeah.
getting behind, and next, you know, we just, our meetings are going till, you know, midnight, 11 o'clock. It gets piling on by extending the public hearing, so it is nice to get everything up front.
That is exactly the next item I had on my list, that exact item. And it doesn't always refer to a public hearing, it could be a regular business presentation where we get something and I look at it and say, I can't listen to you and digest this at the same time. And the notes I wrote to myself was, I could call for a postponement on that application because we all deserve the opportunity to digest any new information.
So one of the things I'm gonna show you after we get through our training here is how you can see online, you know, the minute we get something in here, it's out online. And I'm gonna show you where to find it, so you guys can go start looking at it the minute you know it's in here. And it might give you an opportunity to be able to look at it a little bit more. Because everything that we send to you is there. With the exception of our reports, right, because we create those based on the data that comes
But
in.
you're
So
also getting handouts handed to you,
Yeah,
like
Michelle,
the,
it's not
the,
that
the
you
night
have
of the
stuff
meeting.
to-
a lot of it's just reinforcing what they're trying to show you, so.
Yeah, this isn't, that has nothing to do with, you know, the quality of service that you provide.
No, I'm not taking it that way, I get it.
Good. I only had one other thing, and this is a real minor thing, but Article 18, it talks about committees. There's a reference to standing and select committees. I've been on this commission 7 years. There hasn't been a standing committee that I'm aware of, and I don't know that we need that. If we need a special committee for something, we create a special committee, like I was on for signs.
Like the Wheeler Road project, that was,
Yeah, I mean, I think we've all been on,
So 1 and 2, you're saying probably aren't necessary.
exactly.
And I can say that I can't recall a standing committee either ever being formed. We do a lot of special committees, you know.
That's all I had, but I'm gonna, if I may, just comment on one of the things that was discussed over here with Stephanie and Kevin. I struggle, when we have a public hearing and there's a lot of information and there's a lot of testimony and it goes into the night and that application is also part of regular business and we don't get to it because it's already 11 o'clock and we have to come back in 2 weeks to decide on it, I forget a lot. I mean, I can't, even if I read the minutes, what I am going to try and do is limit our agendas so that if an application is both part of a public hearing and regular business, I really want to get to both things on the same night. And that's not a bylaws thing, that's a protocol thing.
And the only comment I'll make about that is we, obviously we'll work on the agenda and we schedule it quite often that way when we know it's a public hearing that a decision is appropriate. I always feel a little bit funny when it's a public hearing, when we know we have a lot of public coming out that are gonna offer testimony to have it on a decision 2 hours later. I just feel sometimes that this, that you haven't really digested the public comment, you know, some of it's handed in, you haven't even gotten it yet. So I think we can work together on that, but that's kind of a little bit of just some consideration on putting an agenda together, in my opinion.
Yeah, exactly. And one of the things that is a little bit different from the way Steve operated is when we have an application and a public hearing and it's controversial and we get, 4,000 letters. My thought is to read a couple of the letters into the public record at the public hearing that kind of represent what people are writing in and post the others for public consumption on the website, so that we're not spending 2 hours reading letters into the public record. I don't know why we have a need to do that.
And also, doesn't happen very often, but we've seen it a few times where somebody comes in for a TNC and they're behind, they're gonna be sitting there for
Well, remember, we
hours.
changed our TNC rules, so that won't happen anymore.
that's right.
Oh, yeah, okay, but, you know what I'm saying, there's something that's very minor,
We try to put things quicker.
so if we could
Yeah,
kind of
get 'em
just
in and out.
change, we've done it a few times, we're like, hey, we're gonna go out of order, we're gonna listen to this first and act if
We don't
everyone.
have to be sequential.
Any other discussion on bylaws?
Oh, good stuff. Paul.
Going once, going twice, nothing?
I have a
We
question.
covered it?
I'm sorry, Chair. On the last suggestion that you were saying, if you decide to read a couple of things, what would be the selection criteria? Will be one pro, one con?
Hard to say at this point. I mean, as the chair, I will probably read every one. And, I don't know exactly how I want to play that at this point, because I don't want to be unfair to anybody. But, when 60 Minutes does a story on something, they get thousands of letters and they choose to put, 2 or 3 comments from the public that are supposed to be representative of. So maybe something along those lines, a pro, a con, and, something else
Can we do an
that's.
AI summary?
I don't know how we would get those letters.
You know,
Snap it right out.
what we did with the last controversial application is when we're getting a bunch in there with your agenda, we did put out a packet of letters to you, and we included as part of the agenda packet as an exhibit, and it was referenced as part of that. So we can certainly, but what you're always gonna have some people that are gonna come to the meeting, wanna read their letters, and, but we have done that as far as trying to limit, 2 hours of letter.
As long as we acknowledge it.
Yeah, that
You've
you
been
got
hitting
it,
the letters
people
have
know
been
where
in.
to find it, and they can find it as part of the exhibit.
Again, this could be something, I see myself taking up a lot of your time. Because
That's what my
I'm
time's
gonna need
for.
your guidance and, support, and I'll reach out to the other officers as well.
So going back to the bylaws, what I'll do is I'll draft some changes for next week's agenda and send that out, and then we'll put it on as an adoption at next week's meeting for these changes. Does that sound reasonable?
That sounds great.
Okay. Let's work.
The next item is review of 26 meeting dates.
Josh did a great job to make sure we're not on a holiday or close to a holiday or thinking about a holiday on any of these dates.
Hot summer day.
We goof up every year.
Any comments on this? I personally haven't cross-referenced this against calendar items that could present a conflict, but sounds like Josh already did that.
Yep.
We're good?
We're good.
Note to agree on the meeting dates?
Aye.
Say aye if you're in agreement.
Aye.
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 Any nay? Passes. I turn it over to our town attorney.
Okay.
Do you mind, we have 3 new members, do you mind introducing yourself
Sure, I
formally?
will.
You should be able to scroll with the mouse if it's somewhere there. Where is it?
There we go. Okay, good. Okay. So, good evening for those of you, who's new, by the way? 1, 2, 3. I'm Attorney Rich Corella. I'm an attorney with Updike, McClellan, and Spellacy. I've been town attorney here for 6 years now, 5 years. This is my 6th year, going into my 6th year. And this is the second time I think we've done this kind of training session. I'm town attorney in 3 other towns, and I do these types of reviews and seminars quite a bit. So this is a little bit of a broader one relative to your town, and it does address not just planning and zoning, but the role of the commissions. Tonight we're going to talk about the role of the commissions. I say commissions because this is also addressing wetlands, conservation commission, zoning board of appeals. I'll keep it focused to you guys tonight relative to planning and zoning commissions. We'll talk about actions, making a record. We'll talk a little bit about Freedom of Information Act. The Connecticut Environmental Protection Act is the intervenor statute, so you guys may have that come up from time to time. Some updates on affordable housing applications, some recent case law. On controversial issues, sometimes you have to deal with the press, and then moratoria. You've had a couple of those over the years as well. Okay, different commissions. You guys are, actually you're a combined planning and zoning commission. That's very common in most towns, but some towns have zoning commissions and separate planning commissions. But we'll get into the different roles, but you've kind of addressed, you might have seen that already when you do legislative type of actions of setting the zoning regulation, adopting a zone text amendment to change a regulation or create a new regulation or a zone, or change the zoning location on the map of certain properties. That's done in a legislative kind of planning capacity. Plan of conservation and development is done in a planning capacity. More of like a legislative type of body, as opposed to an adjudicatory body where you have an application, you're deciding whether or not that application fits the regulations you're taking evidence in, you're hearing both sides sometimes, and you sit more of as an adjudicatory body than a planning or legislative body. And we're not gonna talk about zoning board of appeals or and the wetlands agency tonight with you guys, but those are the different land use agencies that are here. Again, your role is, on the zoning commission side, is to enact or amend zoning regulations, change of zones, act on special permit applications and site plans. The authority that gives you the ability to do that is under Connecticut General Statute 8-2 and 8-3. And you, again, act in a legislative capacity regarding zoning regulations and zone changes. And when you, we'll get into this a little bit more, when you do a zone change or a text amendment, the overriding factor there is, does it comply or at least comport with the intent of your plan of conservation and development? So every 10 years, are you doing one now?
No, we just did it 2024, we're good.
You're good. You got another 10 years to go. But looking at your plan of conservation and development as a guide to enactment of zone text changes or map changes. And again, you act in an administrative capacity with regards to like site plans and special permits. And so, again, more of an adjudicatory role there. We talked about this a little bit earlier. You have a specific, you're enabling the town ordinance, specifically calls out that no insurance agent or broker or real estate agent or broker shall be eligible to become or remain a member of the Planning and Zoning Commission. So you just gotta be aware of that. I don't know why that's there. It's been there since 1978. You may wanna talk to the town council about amending that ordinance, only they can amend the enabling ordinance. But there's nothing in state law that, this is not based on state law. I don't know what, it's based on local law. For whatever reason, back in 1970s, somebody didn't wanna have the local insurance broker or real estate agent on the commission, and they got it enacted, and it's been there ever since. So I haven't had it come up, and I don't think we've ever had it come up as a problem, but I have brought it to people's attention. And again, at no time will there be more than a bare majority of any one political party on the Planning and Zoning Commission. That's been in the charter also since prior to this last change, and it wasn't changed this last time. It was enacted back in the 70s as well. I don't know if I'm going right yet. Okay. You have, the law also requires that you have a zoning enforcement officer, somebody that's going to enforce the regulations. And in that case, that's Pam Oliva here in town. And she's been doing that for quite a while and very effectively. Under new law back from 2024, zoning enforcement officers now have to get a certification from the Connecticut Association of Zoning Enforcement Officers. I think Pam could probably teach the class on that. She's been doing it so long. She does a very good job. This slide deck was done 2 years ago, and at that time, there was a new adoption of a residential, you could not prohibit in a residential zone any family, childcare, or group home, or require any special zoning permit or special zoning exception for such operation. So in residential zones, you now can,
Yeah, we have that as.
you already have it. You can't have a special permit.
It's only centers that come in for special exceptions.
Right.
You have some groups.
So that's home daycare. So that was 2 years ago. Last year, Michelle and I were talking about this earlier. There's this concept of middle housing, like duplexes and triplexes, that are now, you can adopt regulations, I don't think you have, right? You can adopt regulations that would permit as of right duplexes and triplexes in any residential or commercial or mixed-use zone, as of right. So if you had a mixed-use residential or commercial property and they wanted to change it to a 2 or 3 family unit up on the second floor of the commercial, let's say, you could adopt a regulation that allows for that under new law. But you haven't done that as of yet.
No, we haven't, and then this newest law, I think, is gonna have a little bit more
Right.
mandate of it, so
Yeah.
we'll have to look closer at.
Yeah, and the new one that just passed a couple of days ago, we've been just talking about as well. So one of your hats is to, again, adjudicate and listen to evidence and determine whether or not to approve special permits. The special permit approval process requires that the proposed use be in accordance with the zoning regulations, obviously. So the use is allowed in the zone. That the standards in those regulations are satisfied, and that the conditions necessary for the protection of public health, safety, convenience, and property values are established. That's kind of the criteria upon which you're reviewing the evidence that somebody comes before you with for a special permit application. And it's your determination whether or not they met that standard. Site plan reviews are a little bit more limited to just whether or not it fits with the existing zone and the regulations. So usually you get a site plan review for size, location, situation on the property, on the lot. If it doesn't conform in a minor or correctable manner, you can ask the applicant to modify the plan, and then you can approve it as modified. You can stop me with any questions along the way.
I just want to point out, we call it special exceptions in our town, not special permits, but they're interchangeable.
Okay.
Yeah, just for anybody that may be confused.
Yep, those terms are interchangeable in law and in different town to town. I think we had an issue with a protest petition, a couple.
Yeah, with the Deming
The
project.
Deming project. Under Connecticut law, property owners of 20% or more of the area of the lots within 500 feet may petition against a zone change, which then would require you all to have a two-thirds supermajority if you wanted to approve that.
And so this law just changed it to 50%.
This new one, did last week, yep, yeah.
So now it's 50%.
Of the-
Property owners?
Well,
the area.
There's 3 different criteria now. They have it.
Oh, see.
It's 50, like, let's just say you were gonna put a new zoning classification in. If 50% of the property owners within there of the property that's owned, 50% of those people protest it, or 50% of the owners protest it, or 50% of the people within 500 feet protest it, of course, it's a 2/3 majority. So there's 3 different.
So they got rid of the area of the lots, or they just?
No, with there's still the 500-foot area, like if it's a zone change of a piece, you still have the 500-foot area as a threshold too, of 50%.
Okay.
So there's 3 different ways it can be looked at for the 50%.
Thank you. See,
Yeah, no, I just read it
I learned
today.
something tonight.
So,
And then, just the other thing is that you're required by statute to record or transcribe public hearings. So the public hearing, and it's open to the public, and there's a record of it. And that's really what you're doing, is creating a record.
Excuse me a sec, so on the protest petition, that would mean 6 out of 7.
2/3 majority, you're 7, it would be 5 out of 7. What would 2/3 majority be?
That's not 2/3.
So on a 7-member commission, 2/3 would be.
5 out of 7.
5.
5.
No, it's not. 5 would be 2/3 if you had 7.5 members.
Oh, I see what you're saying.
2/3 of 7 is 4.6, so it would be 5.
It'd be 5. Yeah, it's 4 point,
Okay, I'm
it's
being too
4
literal.
It's
Okay.
no, it's 4, you're right, it's 4.6, it's 2/3 of 7 is 4.6.
So we're rounding up.
You gotta round up, yeah, so it's 4, right, so it's 5 people.
person.
It's not 4 2/3 of,
Okay.
it's 5.
But it would be 2/3 of whoever, the number that we're sitting at any given time, correct? If you only have 5 people sitting, or do you have to, does it invoke it based on the commission number? Or
I
was-
have to, you know what, that's a good question. Some statutes say 2/3 of the total member of the commission,
Okay.
right?
not
So
the city
I have to
commission.
think, I don't
Yeah.
remember that off the top of my head.
Fortunately, we don't run into that very
yeah.
often, so.
This, I don't know, for some of you who've been around for a while, this DMV location use approval was a bogeyman of land use attorneys, because it bounced around. For a number of years, it was the Planning and Zoning Commission had authority to decide where a gas station or a dealer repairer service station could be located. Then it went over to the Zoning Board of Appeals, then it went back to the Planning and Zoning Commission. And this most recent iteration in 2023, It says it's up to the zoning enforcement officer and the building official and the fire marshal. Can certify where the location of one of these types of DMV uses can be, for repair of motor vehicles. And that, so I don't think you see them anymore here, right?
Well, no, well, we do see them in that, you know, they have to conform with zoning. So we have them in our zoning regulations where you can do automotive repairs, and if it's a for sale, it may have to have a special exception. So we review them based on the
Zoning
site's record.
Okay.
Yeah, so we might sign off on them if it had a pre-existing use, or it may need a commission approval. But we do see them still pretty regularly.
We've done 5 this year.
Yeah.
Your planning commission, when you sit as a planning commission, again, your role is to adopt the plan of conservation and development, sometimes to adopt or amend subdivision regulations, and also to act on subdivision applications. When you sit, when you're reviewing a subdivision application, you're really sitting as a planning commission. Actions regarding the plan and development of plan of conservation and development. I don't know why it says it that way. It should be the plan of conservation and development. And subdivision regulations, those are legislative actions. The action itself on a subdivision application is an administrative action, so does it meet your subdivision regulations? And you can't disapprove of a subdivision application on the basis of standards not contained in the existing subdivision regulations. So people have the right to subdivide their property as long as they don't create non-conforming lots and violate your subdivision regulations. Zoning Board of Appeals, we're gonna just kind of skip through. You know that there's a Zoning Board of Appeals. It's not there to sit and oversee your actions. It's to give some relief to property owners if there's an enforcement action, or if there's some sort of inability to meet the zone because of a hardship, and they go ask for a variance. But that's not really your role. They don't have any oversight over your role. So it's not when somebody comes to you for an application and you deny them that they can go to the Zoning Board of Appeals. They can take an appeal to the Superior Court. That's not the role of the Zoning Board of Appeals. Sometimes people confuse that and they think, oh, I can go to the ZBA. No, only if you have a variance from one of the regulations, and or if you have an appeal from an enforcement action. And this is just standards for variance approval, you know, some sort of hardship, and no substantial effect on the plan of conservation and development. And then a Wetlands Commission also, you know, in all towns, the Wetlands Agency is designed to implement, but is essentially a state statute relative to the wetlands laws. So we will talk about, we talked about this a little bit, legislative action versus administrative action. Legislative action, you have a lot greater discretion when you're acting legislatively, so it's your call as to whether or not you want to adopt a new zoning regulation for a particular type of use, or if you want to change the location of a particular zone in town. Those are legislative actions, and as long as it's within your statutory powers, which it is, and you're not, you know, acting in contravention of your plan of conservation and development, you're pretty much bulletproof when it comes to legislative actions. You can choose to do that. Administrative actions are more restricted. Basic role there is basically to determine whether or not the applicant is meeting the regulations. Do they meet the standards that are set forth in your regulations? Most applications require a public hearing and publication of legal notices. You know, those are mandatory in order for you to have jurisdiction over the action, so there has to be notice of a public hearing. And the public has to have the ability to come in and talk about it. You can manage, you know, getting back to your earlier point, you can manage the way you handle that public portion of the meeting in a variety of different ways. Like you were saying, you could say, okay, we got 30 letters, 16 were for and 14 were against, right? And you know, I recommend that the commission review them, you know, and leave it at that, right? You can read an example of one. The issues that are, the people are for it, they want the economic development. The people that are against it, they don't want the traffic, right? Or, you know, whatever the topics are. You can do it that way. When people come to the front and they want to talk at a meeting, you can say, okay, you got 2 minutes, all right? You got 2 minutes, and because we have a lot of people here. And if you start hearing the same thing over and over, you can say, okay, people, you know, we've heard already 5 times that you don't like the traffic, right? We get it, right? And, you know, raise your hand if you don't want the traffic, and everybody's hands goes up. There's a lot of ways that you can manage the time of your public hearing and still give people the opportunity to be heard. You know, I'm just putting it out there, you know. I've seen certain commissions limit, we have 30 minutes for the public hearing. We're gonna cut it off at the end because we're not gonna be here all night. We have other business to attend to, right? And so you can do it that way too. There's a lot of things that you can do in that regard. So if you have a contentious one and you wanna talk about that, and it doesn't have to be the same for all public hearings, right? So if you have a large one with a lot of, you know, a lot of interest, you can tailor it for that evening if you need to. There's statutory timelines within which you have to make a decision. It's the 65, 35, 65 kind of pertains. You have 65 days to open up the public hearing once you get the application. You've got 35 days to actually hold and conduct the public hearing, and then you have another 65 days to decide. You can apply a 65-day extension to any part of that timeline. So if that public hearing goes over to the next month or the next meeting, you can extend that. And then the applicants have 15 days to appeal from zoning and planning and zoning board of appeals actions. You don't have 30 in your regs, right? You have 15?
We don't have no regs, it's just.
It's statutory,
It's just,
yeah. They have 15 days.
From
From the notice of publication, yeah, from the time that the notice of the decision is published in the paper, which someday we'll get away from that.
I was gonna ask that question.
They have 15 days to appeal. All right, so this gets to, you know, improper actions or participation by commission members. There's always, not always, there's sometimes a challenge to one or more of your actions based on a variety of different reasons. One is that you weren't sufficiently prepared to participate and decide it. You know, if you have not attended any of the prior meetings, come totally unprepared and don't know anything that's going on, and then decide an application, that could be a basis for somebody taking an appeal saying, look, I didn't get a fair shake. You know, they were totally unprepared. They didn't know anything about it. So you have to be sufficiently acquainted with the issues and the evidence and what's been presented. Now, you can miss a meeting and you can say, look, I looked at the minutes, these are videotaped, I watched the video, you know, I'm aware of what was going on, I'm aware of the application, I'm aware of what's being said, I feel adequately apprised to act on this. Like I said, you can listen to the tape. I should probably update the video. So that's one of the reasons, that's one of the ways that applicants, if they take an appeal, might say that you didn't act appropriately. Predetermination is another one. The issue there is whether somebody was so close-minded that their mind was made up prior to the public hearing. There's a presumption that you're unbiased. It's up to the applicant to say that, to show some sort of bias. And that's a heavy burden on the claimant, because they'd have to really prove that you have made some prior statements or said, I am never voting for that top, you know, I'm never gonna approve something like that. And then you get an application for something like that. And you're out there already on Facebook or whatever saying, I am never gonna allow a group home for mental health patients in residential neighborhoods, right? And that's it, never gonna happen. And somebody comes in with an application for that, and then you're like, oh, shoot, you know, you're biased, right? And if they've done their homework, they might even call you out on it. But that's the kind of level of predetermination that the court looks for. That's the Supreme Court has said the disqualification based on the face of allegations if the commission members actually made up their minds prior to the public hearing. So you actually made up your mind about a topic prior to actually hearing a public hearing. That's a hard burden for somebody to prove, unless you're out there saying it. So don't say it. Yeah, evidence regarding remarks made prior to a public hearing. Oops, sorry. Did I do that? Yeah, there we go. You're allowed to have opinions, so this, you know, just so we're clear, right? You're allowed to have opinions and perceptions of what policies best serve the general welfare, health, morals, or safety of the community. And that's not a disqualifying personal interest. So you can come to the, we expect you, people expect you to come to that's why you got voted here, right? You ran on a set of issues. This is my view of what's important for the town. This is the way I feel about the general welfare, health, morals, and safety of our community. and I intend to uphold those when I'm elected and put in this position. And that's not a disqualifying interest, okay? So people expect that you have your own personal opinions and perceptions of what's best for the town in a general sense. It's when you come to the table with a predetermination about a particular topic that could be troublesome. Which way am I going? Oh, conflict of interest, okay. Oh, yeah, so if you have, another reason that you would be, you should recuse yourself, quite honestly, is if you have a conflict of interest. That's if you have a personal interest or, financial interest in the application that's before you. Maybe if you're the landlord of a property and your tenant comes in for an application, or if you own the property, or frankly, if you own the property adjacent to the applicant, because you are statutorily aggrieved by being the adjacent property owner or within 100 feet of the property. So you have an interest in that property. And it is a personal bias or prejudice which imperils the open-mindedness and sense of fairness of which you're required to possess. So the interest in the subject matter or a relationship with a party that impairs your impartiality. It's pretty straightforward, but it could come up unexpectedly. Like I said, if you own property within 100 feet of the applicant's property, by law, you're a statutorily aggrieved party, and you could take an appeal if you don't like the outcome. So you have a kind of an interest in it. So just be aware of it. And if there's any question, recuse yourself. That's not the end of the world to recuse yourself for something.
Excuse me, recusing yourself means not being present for the discussion or not voting?
Both. The best practice is to just get up and leave the room and have somebody come get you when that issue is done with. Because you don't want to be, it's one thing to have, all right, I'm not going to vote on it, but I'm going to sit in the audience and I'm going to stare down the chairman and say, all right, you're not going to do that, are you? So you want to get out of the room. That's the best practice.
They actually have to file something with the town clerk on an application that they recuse from. That must be in the charter or something.
I've not seen that. quite
Yeah,
honestly.
so there's something you file with the town clerk if you're not gonna act on an application. It's been that way forever.
Yep.
So it must be
I've
in
not
our
seen that.
bylaws, or it must be in one of the towns. But we do have a standard form. I know several of you filled it out. And technically, you should do that before the application, and it goes on file in the town clerk's office.
Well, there's a standard, there's a policy that they sign off on about conflicts of interest. but-
Maybe that's what, so it's a form that we have.
Yeah, you should have, you probably did that when you were elected.
No, they do this based on an individual
On an individual application?
Yep,
I have not seen that. That's,
I will follow up with
I'd be
you on a
interested to
copy
see
of
that.
it. Yep.
Very harmless.
It is. And we also have a form that we have applicants sign when they come in to talk to us informally that
That
we're
I've
not
seen.
committing.
That I've seen, yeah.
Okay, so, yeah. So I have one over there.
Okay. Another improper action or something that you should avoid is a consideration of evidence after the close of the public hearing. So you have an application, they present, there's a public hearing, people in the community have an opportunity to chime in on it. At some point in time, you're gonna close the public hearing. You vote on, shall we close the public hearing? And that ends the evidence that is allowed to be put in front of you. And it's improper to accept additional evidence after the close of the public hearing, because the public doesn't have an opportunity to comment on that. And sometimes the applicant really doesn't have an opportunity to comment on that either. And so, you can get, opinion or advice or memoranda about questions that you have from staff or attorney, right? Either of us can chime in on questions that you might have about what you heard in the public hearing. That's not additional evidence. That's our advice and counsel to you. You can get professional assistance from consultants if you have questions. That's, again, aiding in your ability to discern and consider what you heard at the public hearing. But you can't get new evidence in after the close of the public hearing. And if you do, if somebody, for or against, right, you can't get people from the public, giving you more information if they're against it, there's a rebuttable presumption of prejudice. And in that case, the action could be overturned on appeal. So taking in evidence after the close of the public hearing is something that really is not good. And then kind of a couple of tips about your practice, and I think you might know this already. You should always make motions in the affirmative. And so if you are going to act on an application that evening, Mr. Chairman, you would say, can I get somebody to move to approve the application? Even if all of you hate it, and you've listened to it, you know it's a non-starter, it's just gonna fail, but you need to have somebody start the process of debating the actual motion. You should always move it in the affirmative. So somebody move to approve it, and all 7 of you can say denied if you want, but the start is to start it in the approval, in the affirmative. Because a vote to approve that fails is denied, right? So if you move to approve it, everybody doesn't, says no, then that's clearly denied. If somebody says, I vote to deny that application, then that's not really an approval or a denial. It's just, they didn't want, it's neither, but under the law. So always make motions in the affirmative.
So if you do that, you don't have to, and once it's failed, you don't have to turn around and vote to give any kind of reasons of why it's denied.
Right.
Yep.
I have a question. It seems like in the last year or so, we've had a couple of denials without prejudice, Michelle? Or is it with prejudice? Without prejudice, right?
Well, you've had denials where you voted to approve it denied, or, yeah, so.
So what does the prejudice part mean? They could come back?
They can come back, yeah.
What we did is we fixed our regulations for the resubmission part of it, so we have some criteria under which you can resubmit to come back. Because we did have someone turn around and come back right away with the same application.
What's your criteria now? Is it
It's
different?
gotta be substantially changed.
Some sort of
Or some
substantial
other,
change, yeah.
or some other criteria. Because what had happened is the motion to approve failed,
Right.
right? And then they just came right back in with this
Same application?
same application like a month later.
Yeah, once you deny something, that should be it, right? And so if there's a new application for essentially the same project, as long as it's changed somehow, right? Is there some sort of substantial change?
This one didn't have one, but,
Okay.
but we will have to now, yeah.
Yeah.
Yeah, we haven't had anything come in.
A reduction
We
in the
deny
number of
with
units, a different way of coming in and out of the property, a traffic concern, more parking, I don't know, whatever their
Yeah.
change is.
And usually what you do with prejudice, you usually are giving an applicant a time to rectify something that is, what you think is rectifiable, usually, right? I mean, usually you're sending a message that this is probably gonna be okay if you get it put together right. Or at least you're gonna reconsider it.
Okay, excuse me, but now, one of the early things you put up there, it said if it was a minor correctable, I think those were the words, that the commission could make the change.
Well, so we often see a motion to approve with modifications come out of your commission, and those modifications are just that, minor things or a bond setting, or, like a zoning data table update, so that's correct, and those I think are the correctable things that's referring to.
Yeah, we'll do that during our
You
discussion.
do that quite often with your motions, yep.
Yep.
That's why they came up.
It's not a substantial difference.
Right.
It's a correctable typographic, or like Michelle said, something to update your zoning table on your map, or whatever it is. Okay, so, the importance of making a record, and this might go to the chairman more than anybody else, but making sure that there's a solid record of what you're doing here. The record consists of the application, the evidence that the applicant puts forth, and the other documents that come in from the public or from professionals, and then also a record, a transcript of the public hearing, and frankly, the video and transcript of your deliberations and vote. All of that consists of the record. The record is important, and we saw this in the Deming Road example, because the standard of review by the court is what I just said. Everything that is on the record is what I just said. The court's function is to review the record. And whether or not, the issue is whether or not there's enough evidence in the record to demonstrate that there's proper support for what you've acted upon. So if there's not a sufficient amount of evidence relative to your decision, then your decision could be overturned. That's why it's important to keep a good and solid record of everything that's you're considering.
So the materials and the contents that represent the record, is that something that staff maintains?
Absolutely.
Yeah.
Okay. I don't have to like go get a garage and,
No, that's all staff.
all right, good.
And we did that, like I said, in Deming Road. It was a pretty voluminous record. And there's a structure to it. There's a structure to how we present it. And we have to file it with the court. And then all the parties kind of poke holes at it and say, this was sufficient, that wasn't.
Okay. And after doing this once or twice, Michelle, you've got that down.
Yeah, as it's gotten more electronic, I think it's gotten
Easier.
a little bit easier.
Yeah.
Josh is good at it.
There used to be binders.
Yeah.
Binders.
We
of
used to say
material.
3 copies of every plan denied,
Suits, I know.
for years.
So the question, though, when somebody takes an appeal of your decision, the question is not whether the court would have reached the same conclusion. It's not up for the court to review it and say, I think I agree with what they did. It's whether or not the record supports your decision. So it's not, the court's not substituting its judgment for yours. It's reviewing the record to determine whether that supports what you've decided. So whether you approve it, and you say you approve an application and a neighbor takes an appeal, which was what Deming Road was, there was sufficient evidence in the record to support your decision, and the court basically denied their appeal. It's the other way around. If you deny an applicant, it's up to them to show, I had more than enough evidence in the record that they could have decided. And even then, the court might say, well, I see a couple pieces here that they hung their hat on, and they decided against you, and that's enough. There's evidence in the record that supports your decision to deny it. So it's up to the court to review the record, not to make its own decision. Right? I keep on saying, I jump my slides. Is the decision reasonably supported by the record? If you've stated your reasons on the record, you don't have to do this, and sometimes it's better that you don't. But if you've stated your reasons on the record, and when I say stated it, as a consensus, have all decided, we're denying this because the applicant failed to show us, evidence of no impact on the adjacent property owner's values, or whatever your decision is, right? If you've stated that as a consensus in a group, then that's the reason as a group that you've denied it, and the court's gonna look to the record to see if there's evidence to support that decision. If you've not stated anything, you just said, okay, we voted on it, denied, then it's up to the court to review the record independently to determine if there is substantial evidence in the record to support your action. So sometimes it's better just to say denied and not, so if the agency has not stated the reason, the court searches the record to determine if there's adequate basis for your decision.
So would that include, like, when we have our final comments during the regular meeting, sometimes we go around the table and the chair would say, well, I support this, but, or I'm not in favor. I mean, is that okay, or
Yeah,
is that best
absolutely.
not to do?
No, that's good.
That's
That's
okay to do?
good, yeah.
All right.
So you're just saying denied. So is there any difference in the motion to approve of a zone change that you're gonna deny versus a site plan, or a special exception? In other words, is there ever a time that you wanna do a motion to deny? Because you were saying earlier you really don't.
Is there every time you want to do a motion to deny?
So,
You were
Instead
saying
of-
previously you
Not
should do a
really.
motion to approve that
Right.
fails.
And then
Right.
deny it.
But it's denied by the motion, by the fact that it didn't.
Yeah, you just vote, the votes, you don't get enough votes.
So then you're never gonna
Right.
have a denial, quote unquote, reason that you're gonna state and put in an approval
Right.
letter.
Right.
You're just gonna say, planning and zoning failed
Voted.
to approve, or
Right.
the motion to approve it failed.
Right.
is what
It
the
is
letter's gonna say.
counterintuitive, right? Because someone has to make a motion to approve,
Mm-hmm.
and then they know they're going to vote no.
Right.
Right,
So it's a bit counterintuitive.
right. Just because you move to approve it doesn't mean that that's how you're gonna vote.
Right.
Somebody's gotta be that scapegoat and go,
There you
"Oh, man,
go.
I'm gonna be the one falling
There
on
you
I
it."
go.
second
Thank
it
you.
too, yeah.
Yeah, so in the court, your findings, your decisions will only be invalidated if not supported by substantial evidence in the record. And the evidence is sufficient to sustain the agency finding if it affords a substantial basis of fact from which the fact of an issue can be easily, reasonably inferred. Okay, so that's, ask me any questions as we go along, if you have anything about that. All right, some FOIA information. Freedom of Information Act is, again, in the conduct of meetings are open to the public. It allows the access to government records and open meetings. Meetings must be open to the public. Whenever you are assembled of a quorum of you, and you're discussing or acting upon a matter that takes place, that's a meeting. If you all bump into each other at, in a park or something, that doesn't mean, social meetings neither planned or intended to discuss agency business, that's not a meeting under FOIA. And then we talked a little bit earlier about executive sessions. And really, there's no discussion of land use matters, or as most other matters come before the land use agency. You don't really have an opportunity or need to go into executive session unless you're talking about settling some sort of litigation. So if we're in court because somebody took an appeal of your decision and we're trying to perhaps settle it, and the settlement requires you to review or possibly rehear a different application from the same applicant, we'd have to come back to you with that, and you would discuss that in an executive session. But that'd be really the only time that I would imagine that you'd go into an executive session. You can only discuss or act upon applications at a regularly scheduled meeting or properly called special meeting. The agenda must be prepared and available to the public at least 24 hours in advance. You can add, so affirmative 2/3, right? So that answered my earlier question. I was scratching my head. So if you were to add an additional item on the agenda, 2/3 of you have to add it, not just a majority, And you can, I don't know if you can do this online. I think typically you'll cancel. Like logistically, you could, if you had the technological capability of moving a regular meeting to an online meeting because there's an impending snowstorm or some reason why you'd want to do it. Otherwise, you just cancel it, all right? So, because I don't think they have the ability logistically to create a hybrid meeting.
No,
Scott would
I
kill
think
us.
under law, you have to be able to do a hybrid meeting if a commissioner requested it hybrid.
We did meetings during COVID.
Yeah, no, we're not set up today to do that as we were then. Let's just put it that way.
What happened?
Well,
Did you rent all that stuff?
well, we were
Let's be
doing
thankful.
WebEx and.
So it does bring a couple of good points
Those
up.
are the
So,
worst years of all.
That's true.
so you meet in person, but let's say one of you cannot attend because you're ill and you're in bed, but you want to participate, or they need you to participate to make a quorum. You can participate electronically. You can call in, or somehow phone in. As long as you can be heard and you can hear on your end what's going on here, you can participate remotely. And that doesn't invalidate the meeting. It doesn't turn the meeting into a remote meeting where the public has the ability to do that. Just as a commissioner, if you want to participate, you physically can't be here, you can still call in and participate, okay? And sometimes that's important, especially if you need to make a quorum.
I think sometimes the only request that IT has is that we get like a 48-hour notice, if possible, because again, there is some logistics around it. But I know they've done it for other commissions where they've had to, so.
Yep. I don't know if you might have run into this. Have they run into interviewers?
Most of these people haven't here, but we have years ago with Evergreen Walk, like early 2000s.
The Connecticut Environmental Protection Act allows any individual in the state, doesn't have to be a town member, could be anywhere, any person, it could be anybody, doesn't even have to be in the state, any person can intervene in any public agency meeting for the purpose of protecting the environment. And they do that by filing what's called a verified pleading in the agency meeting that the conduct that's being proposed, the application, is reasonably likely to have the effect of unreasonably polluting, impairing, or destroying the public trust in the air, water, or other natural resources of the state. That is a broad thing, right? Anybody can bring an intervenor petition by filing a verified affidavit that says, I think, doesn't even have to be certified by a soil scientist or biologist. I think that this application is gonna unreasonably pollute the air in our town, and I think it should, I wanna intervene. And, by properly doing it and intervening, that person becomes a party to the administrative agency process, which means that they have the ability to appeal the decision in the event they don't like it. So it's a pretty strong and hefty law, and it's pretty powerful. If you get one of those here, first of all, talk to Michelle and talk to me. Secondly,
That is part of what we're dealing with the Talbot Lane lawsuit that's still
that's what
ongoing.
I'm saying.
Okay.
They were interveners.
There's interveners there?
Yeah, that's what that was.
the step here is, there's really two steps. One is to determine if what they're submitting actually consists of a verified pleading. You know, I've seen people try to intervene under 22A19 and say that the traffic is gonna be killer. I don't want this much increased traffic. Unless they're saying and tying it somehow to the pollution or the runoff or something with the air, water, or other natural resources, that in and of itself is not an environmental intervention. It has to show that there's some impact on the environment that they're alleging. And so that's the first thing. Is it what they're proposing an actual verified petition about the environment? And then there's another
So,
step.
question about that. Air, water, or other natural resources, does that include noise?
No, I don't think so. That's not a natural resource. It has to have an unreasonably polluting,
Wildlife.
impairing, or destroying air, water, or other natural resources.
Yeah, wildlife.
Wildlife.
Wildlife, yeah, that's a natural resource. Yeah, but noise is not really, I wouldn't consider that an environmental intervenor pleading.
That would be a different issue.
I think it's a different issue, yeah, noise,
Rich, what about the night sky, ambient sky?
like light pollution. I haven't seen a case like that yet, but I could see that, right, where there's too much light,
Sure.
yeah.
Can't see the
Yeah.
northern lights.
So is it two steps? The first they have to have it verified and then the commission has to act on it.
That's right, that's where I was going, is they have to submit it, and then you have to do two things. Is it a verified pleading? You're gonna make that determination factually. And then you have to determine whether or not that, you have to vote on, all right, we're gonna allow them to intervene under the statute. We feel that they've met that burden.
Instead of somebody just being a nuisance, like somebody just that doesn't want it, they can't just file the paperwork and say, I don't have any facts behind it, but.
That's right. Verified pleading is, verified pleading alleging facts, right? Here's a list, so I'm telling you that by allowing this application, you're gonna pollute the Scantic River, or whatever, up there. And here's why, because the runoff from the parking lot that they're proposing is gonna unreasonably pollute that waterway. And I've looked at it, and, you can see by, a list of facts, and I'm swearing to it, and I wanna intervene for that purpose, because I wanna protect that waterway. Okay, they've fled it, it's signed, right, it's submitted to you. I'm now an intervener. Bingo, that just made myself an intervener. You gotta vote on it. If you deny my right to intervene, I can appeal your decision to the Superior Court. I submitted a verified pleading. It has to do with the public trust of water, right? I think the application was gonna unreasonably pollute it, and I should have been allowed to intervene. So you gotta take it seriously, as if there's another party at the table at that point, because that's what they're trying to do.
So, another example that came to mind, I saw in a meeting, I believe back in October, that was the potential water table issues where it could, due to, I don't remember which one it was, neighborhood being built, there's a risk of the water table increasing the chances of flooding. And by the way, that was looked into.
I'm not too sure which application you're looking at.
I-
Talking about.
I just remember a citizen bringing up the possibility of like risks of flooding.
That was on, Chapel Road.
Yeah, I think the
Yeah.
town engineer did respond to that and did, provide information related to that topic.
And, people can get up at a public hearing and say what you just said, right? I don't like this application because of flooding, and you guys need to look at this. That doesn't make them an intervener. They have to actually file a verified pleading, so basically a sworn affidavit in writing, signed by them, right? A verified pleading, okay? That says, I believe the conduct is reasonably likely to have the effect of unreasonably polluting, impairing, or destroying the public trust. And it's gotta be pretty substantial, just because they said it, it's like, what are their credentials for saying that? Like, what do they base that on?
So they can't just go up there and to a public hearing and say, I think this is an issue, like, we can take it into consideration, but at the end of the day, it's not something that's like a fully applied intervention.
That's right. Yep, people can express their concern about it, doesn't make them an intervener. They have to physically say, I want to intervene in this under the statute. Here's my verified pleading and my verified facts of why I think this is gonna impair the public trust. And, you can review it, and then you can decide amongst yourselves, you can ask them questions. They wanna be a party to the action, they wanna be a party to the application. The applicant typically does not want them, right? So you're doing this over the applicant's, concern as well. They have the right to ask them questions. It can be kind of a little bit of a cross-examination. And then ultimately, it's up to you to decide whether or not that party should be allowed to intervene. That's, yeah.
Is there a limit on the number of interveners?
Yep. Yep. So that you should keep it to a high standard, right? And if you say that you're not going to allow them to intervene, there should be some pretty good factual reasons why you don't want that. I think before you get to that point, though,
Will the consultant do?
we'll talk, right? Yeah. All right. All right, so affordable housing. This is a very fluid, actually the picture is actually pretty good. There's a pretty fluid situation going on right now with affordable housing, because there's been a big push by the legislature to allow and promote more affordable housing in communities through a variety of different stick and carrot statutes. Right now, so you've heard of 830G statute. The statute 830G is the Affordable Housing Statute in Connecticut. It basically, what it does is it shifts the burden. Once an applicant wants to come forward with an application for affordable housing, you have an obligation to kind of review those things, those applications. South Windsor does not have 10%?
No, we do not. It's about 6.5, somewhere around 6.7.
Remind me, did you have a moratorium?
Yeah, we had a moratorium that expired over a year ago, so we no longer have a affordable housing moratorium.
So you have to hear these applications and you have to decide on them. And you can't, affordable housing allows for a certain number of the units to be available to applicants and families whose income is less than or equal to 80% of the area median income. And in some cases, it's 60%. And if you can review it as you normally would, but you can't use the affordability aspect as a reason for denying it. And if you were to deny it, the burden then shifts on you if the applicant were to take an appeal as to why you denied it, and whether or not your reasons were for health, safety, and other reasons, and not just because of the affordability aspect.
So, excuse me.
Yes.
The commission does have the right, under any conditions, to turn down an application?
You
that
can turn down
includes
applications, that don't meet your regulations. So if somebody comes in with a 830G affordable housing application and the density is so high that it would not meet your regulations, right? It's, more, you don't have enough room for parking. It's gonna increase traffic tremendously. It's gonna eat up 90% of the ground cover and, turn it all into a parking lot. And there's all the things that would not meet your regulations to begin with. You can deny it based on those regulations. So they're not entitled to the development of whatever they want to do just because it's an 830G application. What you can't do is say, we don't want to approve this because it's going to bring in a population of low-income people with perhaps some children that are going to fill the school system, and it's going to burden our town economically with a greater school budget and all the things that you hear about. So, you know, so there's a streamlined appeal process. If you were to deny it, not based on health and safety reasons in your regulations, but for other reasons like I just described, then they would take an appeal, and there's a streamlined appeal process in the court system under the 830G statute, and you're denied. So there are recognized grounds for denial. I guess we kind of jump to this slide. You know, if it's necessary to protect the substantial public interests in health, safety, or other matters which you may legally consider, that's fine. And those interests clearly outweigh the need in the town for affordable housing. That's kind of where you start getting this little pushback, because under state law, you should have about 10% of your housing inventory as affordable housing. You don't. And a lot of towns don't. A lot of rural towns don't. And that the public interests can't be protected by reasonable changes to the plan. You should identify those specific public interests that you are seeking to protect by your denial, like we just described. And you must state that reasons on the record, and it must take the form of a formal, official, collaborative, collective statement for the reasons for your actions. So if you were to deny an affordable housing application based on, you know, health and safety reasons, you have to kind of state that for the record, because the burden shifts to you on the appeal to prove that.
So, we do walk a tightrope when it comes to housing that puts kids in schools.
Yeah.
Because, I mean, we simply do, and we struggle with it as a commission. I don't know that I have the answer. I don't know that any of us have the answer. I don't know that there is an answer. I guess we just have to look at each case individually, but it's a tightrope.
Yep. Yep. It's one of the best parts about your community, and it's also a tightrope financially. You know, you're the only community in the state that's had an increase in the school population. Everybody else is losing kids.
We are the outlier.
You really are.
There's
Yeah.
one or two that have increases, but nothing like us.
Right.
No,
Right.
we're
I mean,
the
the-
number one.
I think that's a positive. It may be a
Yeah.
burden financially, and I get that, but I think that's a positive for your community, personally speaking.
It's just what good planning you've done over the years.
It's starting to tax the
It's starting to
resources.
financially starting to come back
It's-
around. Yeah, I get it.
it's- You know, and then when you, in the previous slide where you talked about the health and welfare,
Yeah.
you know, I guess until it gets to the point where our fire marshal or police chief goes, hey guys, you know, we're on the tightrope right now with, you know, fire rescue and, response times with volunteers. We're on the cusp. Until somebody says that, if they do say that, if we get that from our police and fire, that gives us grounds.
Yeah, to deny an affordable housing application. Yeah. And that's what this slide says. The burden shifts to you, the agency, not the applicant, but you must marshal the evidence that supports your decision in order to persuade a court that the evidence is there to support the reasons why you denied it. So you gotta marshal your evidence. That's why it requires you to state collectively why you denied it, what those reasons are, and you need to have that kind of substantial evidence. But I can envision circumstances in town, you know, we're just talking about at the town council the other night. There's a couple of these streets don't have adequate fire protection.
Correct.
If you have an applicant that wants to put 25 units of whatever, affordable housing in there, and he's trying to use the affordable housing statute to kind of force your hand to do that, you can say, I think with a straight face, that we should not put 25 units on that street. It doesn't have adequate fire
How about,
protection.
how about with, our water pollution control with WPCA as far as being capacity?
That's a little bit harder because I think, when you say they're at capacity, they don't have enough water to supply.
No, as far as our sewer treatment plant and stuff like that, which is in,
I've never seen a residential development tax of water treatment facilities so heavily. That's usually like a commercial use that would really overburden the sewage treatment facility. I think 25 units, even 100 units.
I think we've had some concerns with
Yeah,
areas
but
where we have the
there's
pump
concerns that are
stations.
being reviewed and addressed and whatnot, but they're being monitored as to,
Yeah.
but we're not out of capacity at this point. But it is
No, but we
certainly
do,
something that
the areas that have pumping stations are,
and they're looking at those
critical
pumping
path.
stations to see if what they may need to do to upgrade or to use them differently. But it's an ongoing review, but with every project that comes in, obviously
Yeah.
it becomes something we need to be talking about.
Even if you could show it though, that there was a problem, that the problem has to outweigh the need
Mhm.
for affordable housing. So it's a bar there.
With House Bill 8002,
Mm-hmm.
that progress that will get us from 6.4 to whatever, it's tied up to money and grants that in 2028 we may not be able to do it if we don't have a plan for this.
Yeah, that's the new law that just passed. We're still getting up to speed on it, quite honestly. So what are you referring to? And what aspect of it? Because I haven't heard that part of it yet.
Yeah, it's the grants, the financial part, which on one side I'm here that it's taxing. There can be like a financial burden, but at the same time, not having a plan may impact us financially in 2028.
Right. If you don't have an affordable housing plan that complies with that new law, I think you're right. I think you're gonna have
I
inability.
think
to
you
get
lose
state grants.
eligibility for certain types
I
of
think we all have
grants.
to learn a lot though before we.
Oh, yeah.
Because,
Yeah.
because we have to opt into it and we have to have a plan in place.
You
This
have
is
to
not,
opt in.
this is not just a mandate saying you need to do this, this and this. We can have our own plan.
You can have your own plan, and I think there's also some sort of credits, right? There's housing
Yeah,
unit
there's different,
credits levels of
there's
it.
all sorts of
Yeah.
different ways, like if you do certain
Carrot.
things, you can look at your 830, your points differently for an 830G.
Yeah.
There's also going to be an analysis of the 830G numbers
Right.
that are supposed to be done by early next year, and whether those numbers make sense for communities or not. So, I mean, there's a lot to
There's a
stay
lot-
tuned about
there's a lot
on
going
this,
on there.
yeah.
Some recent cases, some, somewhat recent. These are, let's go through them. So this was a denial of an 830G application in Glastonbury. The reasons being traffic, preservation of open space, and endangerment to potential future public water supply. And the Supreme Court actually focused on the second reason here, the preservation of open space. The particular property in this case in Glastonbury had been identified in numerous years of applications and discussions at the town council level to recommend that it become a open space parcel. And they had a whole long history. It's important for the town, it was in their plan of conservation and development, all recommending that this be considered for the town's purchase and preservation as open space. And on appeal, because the burden shifts back to the town was required to establish that it reasonably could have concluded based on the evidence that the preservation of open space could not be protected if the zone change were granted. In other words, there's not that balance of it. Can we allow the affordable housing in this area based on what they're applying for, or are we gonna lose forever that open space opportunity? And here, the court found that was an important public interest that clearly outweighed the need for affordable housing. You can't get open space back, right? And you can't undo that. Once you've developed it, that's it. It's no longer open space. I think the real determination here was that they had identified it year over year. It wasn't just a pretext, like, oh, we wanted that for open space. No, if that ever becomes available, we want it for open space. We gotta approach the owner for open space. They did it year after year after year, and when it finally came to an application for an affordable housing development, they said, no, we want that for open space. That's an important thing. And they actually, they won on that. The Supreme Court concluded that the record was replete with evidence that since the 71s, continuing to 94, just a few months before the application, the town had viewed the parcel along with the rest of the MDC land that was particularly appropriate for open space, not only for their town, but for the greater Hartford area. So like, it was really an important public interest to keep that as open space. And that's what allowed them to deny the application and not have it overturned on appeal. So that's kind of what you were getting to before. There's gotta be some real hard evidence that there's an overriding public interest, whether it's health or safety. In this case, it was open space. It can be other types of things as well, but you have to have real clear evidence about it. Yeah, just, you're right. The court was very clear to say, don't anybody else get any ideas about this. It's not to say that it's simply because the affordable housing application is for an undeveloped parcel, that's all that's needed to justify denial in the future, right? Don't get any crazy ideas about the rest of your towns. That's what the court's saying here. Yeah, all right, so, yeah, this is what we just talked about. Lynch versus Freed, this kind of goes back to the issue of your own personal view of the world and what you bring to the table as commission members, and your particular, view of things. In this case, there was a public official that was putting out in his LinkedIn or social media page that people would it was private, his private social media page. He was putting information out there about personal life updates and job-related information, and he interacted with his constituents on Facebook. And sometimes he deleted comments that he found that he didn't like. Well, he was a public official. In that case, he was the town manager, so it's a little bit different there. But he deleted people's posts about the way he was running. This was during COVID, about the way COVID was being handled in his town. And one of his constituents sued under civil rights laws, saying it was a violation of his First Amendment rights. And the court ultimately said, look, he's not acting on his own. He's not acting with the authority as the town manager when he's posting on his own personal Facebook page, and it didn't allow he did not engage in state action when he blocked the individual, as his Facebook activities were private, and the blocking did not make him liable under civil rights statutes. My point being, be careful about what you post, if you post online. I'm not online. I'm not on social media. So some of the younger crowd might be, and just be careful about what you post, and realize that don't post about things that are happening here. Let's put it that way. The other thing I admonished the town council about the other weekend, don't text during meetings. Okay, people will see you, especially if they're videotaping these things. They will see you texting and think that you're texting people in the audience or at home about what's going on here and getting side comments about it. And actually, it's a violation of the Freedom of Information Act to be communicating with people outside of this board while you're deliberating and acting on people's applications here. Put the phone away, right? Don't text. But you'd be surprised how many people text during meetings, and people get upset about it. And there have been cases where your personal phones have been subpoenaed to see what was it you were texting about while you were in the meeting. Was it with somebody in the audience, right?
Sometimes I think commissioners want to Google a solution too during the meeting, and you really shouldn't do that.
You shouldn't be doing that either, yeah.
How about like Google Earth, like just zooming in on it, just to
You may want
to zoom in, just to get yourself a little bit more of a reference.
And then, look,
something
I get it, it's a tool, right? And I use it for a lot of the same reasons that you just said. Like, you can see it on Google Earth, and you might want to say, if you're doing that, Mr. Applicant, I'm looking on Google Earth, and I see over in the northeast corner, there's a huge, you excavated a huge bunch of material out there, but I don't see that on your plan. You could say that. Like, that's okay. But I would say it, though. I would say it for the record,
That won't stop an FOI if we say it.
Will it stop FOI? Not necessarily. I mean, people can file FOI requests for just about anything. There's a whole bunch of exemptions, but that's not one of them. If you're texting during the meeting, just stay away from it.
And we give you guys aerials too, so you wouldn't need to be looking at Google Earth.
And
Sometimes
right,
you
and they're
Zoom out a little
current.
bit and
Do you throw up Google Earth or anything on like a screen or during applications? I know some towns actually will do that for, you know.
Sometimes an applicant will bring it, but
Sometimes the
we've
applicant-
given, you know, a map ahead of time,
Yeah, no, I think
an
like,
aerial ahead of time.
like a lot, I've seen a couple towns, they have a GIS system on their website, and they'll say, okay, to give the commission even an overview, here's the parcel we're talking about. It's on the corner of, you know, where this road and that road,
is
here it is.
we have the best GIS system
Yeah,
in the
so,
area.
so
Yeah.
we'll give them
You
an
can go
aerial
back,
with their
you know.
packets of the property,
Yeah.
yeah, so.
2019, 19, you know, you can go back every year incrementally and
Yes.
look at that aerial
Mhm.
back to 1956, I think.
It's hard to tell us you had something when we don't see it from the aerial.
I mean, there has been times where I've gone, like, we get our packet, I go to a site and kind of wrap my head around what we've been given, and then I'll take some photographs so I can have my own thing, and I'll look at my pictures while, I guess I won't do that no more.
A couple other cases, this is Gilead Community Services versus the town of Cromwell. This is a couple years old, but it was pretty impactful, because this was, a town that did not have a real good definition of what was allowed in their residential zone, and I think I kind of referenced it a little bit earlier. This Gilead Community Services, was having, basically what's the word I'm looking for? They provide individuals with disabilities fair housing by putting them into residential communities. So they have a home in your neighborhood, in a regular residential neighborhood. They would buy a home, and they would put 4 or 5 people, typically the same sex, men or women, into a home as a residential setting for them to live. And they'd have a care manager in there. And the town, the town shut them down, right? And they had an application, they forced them to come in for an application to use the residents as part of their services. And the town denied their application. And they sued the town and got a huge jury award, got an absolutely huge jury award. And a lot of it was because the town's speech and actions outside of the zoning activity were what we were talking about before. I am never gonna allow that in this town, right? We are gonna shut them down, right? And that's the kind of words that they used and said. And they got a jury verdict, the multi-million dollars against the town. So just be careful about how you address these things. I mean, you have a contentious application, it's something a little bit out of the box. Talk to the town planner and myself. We can steer you, I think we can steer you right to it.
Try.
Dealing with the press, same thing. You should not be commenting to the press about applicants or the reasons for your decisions. Let the record say that.
It's all fake.
And leave it to the town attorney, and the town planner. And then moratoria, we've had a couple moratoria over the years, whether that be for affordable housing or trucking distribution facilities.
Residential.
Residential
Yeah.
ones. They serve a purpose. They should be for a limited period of time. You can't have one that goes on for years, because that's basically a denial of people's rights. But to stop the filing of applications for a certain period of time while you get your regulations together, maybe get some consideration as to what should be in your regulations, if there's a new booming area. I've heard this, I've heard this about data centers, because they suck up so much energy. People are saying, wait a minute, we don't want another data center in our town because we don't have the electrical capacity. Not so much in this area, but I've heard about that. And so the moratoria serve a purpose. And you guys have done it well in the past. Limited period of time, usually less than a year, and gives people the opportunity to kind of get up to speed. I know in my office is in Middletown. There was a huge, I guess blossoming is probably the wrong word, but these vape shops where it's not cannabis, but it's vape shops, smoke shops, right? And they started popping up all over stuff. And all of a sudden, they're considered retail. They have no regulations around them. And all of a sudden, they're getting arrests made, and they're selling cannabis and other stuff out the back door. And so they put a moratorium on all of them until they could get some regulations around how to deal with what is otherwise a benign, cigarette store or whatever. It's okay, it's a legitimate legal product that you're selling at retail. It's otherwise approvable, but they treated it as retail and then it just got out of control. So there's reasons for moratoria. You seem to have done well in the past about them. That's basically the 1984 decision saying it has to be kind of limited in time for a specific purpose, maintain the status quo while more comprehensive zoning regulations were considered, and the town formulated a comprehensive plan around that topic. I don't want to skip through too much, a lot of moratoriums. Yeah. We're just trying to be cognizant of getting you guys out of here at 9 o'clock, not too late.
Questions? Speak up, now's your opportunity. So, earlier, when I talked about us getting together as a group to discuss things relevant to us, a great example came up in your presentation, and that is our need to really understand housing legislation. I would love some kind of session where maybe it's the two of you, but experts can present to us where we are, what is going on, what's the latest. The training that some of us did on Saturday, there was an hour and a half on affordable housing, but that was general to the state. We need something that, we can interpret because it would be unique to us and our needs and our situation. Is that something that's possible?
Yeah, absolutely, yeah.
I don't know the best.
We're wrestling with it too, because it's so new. And it's changed 3 times in the last 3 years, so.
It's really 2 parts, Paul. We can talk about this legislation and the impacts of that, and then secondly, I made a presentation fairly recently to the Fair Rent Housing Committee, really updated information on where we are as far as affordability in our town. Even with projects that we're thinking about, and whatnot, and I would be happy to share that with the commission too.
Yeah, I mean, you all agree?
100%,
We
100%,
can use
and
that.
I think it would also be helpful, like, as part of it, to review either projects underway or like pending applications, like that have been talked about, but due to the elections, some of us are new and would probably do with a refresher on.
That's going to happen organically, I think.
I know.
Because like with this meeting, before every meeting, you're going to get the agenda, you'll see what we're going to be discussing. But if you want more than that, by all means, you're entitled to
You
it.
probably do best. Once things are pending is approaching staff for any assistance, really, because you don't really want to go to your fellow commissioners
Right.
about something that's pending. So that's the one thing just to keep in mind.
Thank you.
Where are we? General planning discussion.
Can we,
I
can we,
just-
can we let this guy go?
Oh, yeah,
Probably,
You're
we're
good.
probably done with you.
You good? Okay.
We're gonna go into.
Feel free to ask me any questions through Michelle, if you have any questions.
I did want to hold the two of you for like 5 minutes after the meeting, but why don't I just deal directly with Michelle and
Sure.
she can reach out to you?
Absolutely. Yep.
Okay.
All right, thank you.
Thank you.
Thank you.
So on the general planning, I just wanted to show you something, Josh, maybe you can be my assistant here.
The website?
Yeah, I want to make sure that you're all aware of the Planning and Zoning Commission website out there, right? This is the town's website. So, Josh is gonna get there. I want you just to be aware of that this is where all your regulations are, or your any of your plan of conservation development. Is this acting funny or something?
Just trying to see if we can zoom in.
Okay, there you go. So you would just go to our website and you're gonna go into government.
Boards and commissions. List of all.
Well, that's one way to get there.
Yeah.
A lot of ways you can get there.
You
but
can
you're
also
gonna
go through departments, planning department.
So when you get there, you're gonna see your names out there, your term, that kind of stuff. One of the things, if you look at on the left-hand side, Josh, we put out pending and recently approved applications, so this is what I was talking about. The minute application comes in here, we upload all the data out there, so these are all hyperlinks to the site plans, the narratives, the applications. So when the public calls us and say, I saw the sign over on Griffin Road, what's it for? we can send them right out here, they can look at stuff. Obviously, we have a hard copy in the office, but, you know, this is where we're sending people for information. You scroll down there, you'll find we have years of information out there. You'll find all the documents that were submitted for Kilkenny Heights, for example. I mean, this is a really good resource for appraisers and people like that, but it's a good resource for you if you wanted to see anything electronically, what's in here. So things get out there within a day or two of them being filed in our office. And then the third thing I wanted to show you, if you can go to the planning department website, we're talking a lot about affordable housing. What I want to show you is out on the planning department website, you'll find the second link down as a certificate of completion for October 2020. That is when we applied and got the 4-year affordable housing moratorium. And the only reason I'm sending you there is this is really a good, if you want to know more about affordable housing and how it counts in our town and things like that, there's a lot of documents there that talk about this point system that we have or qualifying units, and it kind of gives you a snapshot of what we have today as far as what is considered affordable housing as far as the state is concerned, as far as units, right? We have not added a single unit of affordable housing since that was put together, just for point of reference. So, you know, we talk about trying to get a second moratorium. We're very far from even thinking of that. So, but I do want you to know that that is out there, and that is something as a point of reference for anybody that wants to understand our current affordable housing. So it takes in the berry patches and the Hillcrest and, you know, all that kind of stuff. And I'd be glad to spend more time showing you that, but I just wanted to show you where it is on the website if anybody wanted to poke around and look at it. And then the last thing, just at the very top there where you see subscribe to e-alerts, if you haven't done this already and you have any interest, you can subscribe for any number of things. Any agenda that gets put out, any minutes that get put out, any legal notices. So if someone calls me and they say, I want to know about such and such a project, I tell them, sign up for e-alerts. You'll get every planning and zoning agenda as an email. You get to look at it. If what you want's on it, great. If not, delete it. So it's a good way for you guys to sign up too. When Josh posts minutes, you'll get a notice that the minutes have been posted. I use it to make sure that he's doing his work, right? So I know that. I'm just kidding. But it is something that we tell a lot of the public, this is a really good way to track your work when they want to know what's going on. Because, you know, people will say, well, can you call me when it's going to get on the agenda? No, but you can do this, and then you'll know when it's on the agenda. So you can share that with people out there as well. I think it's, and then there's also a way too where people want to make a comment on an application. They can, right there on the website, you know, it tells you you want to comment on it, you can send it in. If you don't pick planning and zoning, it comes into the town council and it gets, you know, sorted to us if it's an application, but there's an opportunity to pick the specific commission you want your comments to go to. So I just wanted everybody aware of that, because I don't think we really reviewed too much of what we do on our website.
Is there anywhere on, in that link to get what is the affordable housing, like the formula of the 80% of our, it's in here somewhere.
What is
We
on
did get
here,
a sheet, you gave us a sheet one time.
yeah, what is on here is your affordable housing plan is on there, and it has a sample of it, right? And it changes obviously as the number changes and things. So like we're working off of a 2024 number.
The medium income.
Yeah, so give you a good example is the project that's going on Foster Street. The affordable housing plan that was submitted with that very clearly gives you an example of what one of those units can sell for based on today's numbers, right? So that's probably the best example to look at right now. And that'll get updated as state puts out new numbers because it's based on the median income, you know, so basically what we have at the staff level is we have a spreadsheet that's been given to us from the Department of Housing with certain factors in there. So if somebody has an affordable unit and they want to sell it, we have to take the spreadsheet and work with it to come up with what the sale price can be based on a number of factors. So that's something that is part of the difficulty, if you ask me, from a staff perspective of managing affordable units moving forward, as they are for sale units. When an affordable unit's in an apartment complex, that's up to the apartment owner to demonstrate that they're being compliant with the affordability component. But when it's a deed restricted unit, you know, it's coming back on us to do it. So we only have 9 right now because we got 9 out of our DRZs, Clark Estates, Schoolhouse Road. Those are the 9 units we currently have. We're gonna get a bunch more when we get the ones from the SRDs come online. I'm working with the assessor right now and the town attorney on coming up with a quote-unquote program for resale. You know, we're gonna we have to also qualify people, so there's a little bit to this whole resale thing that, you know, we're not really real estate people. So, you know, you look at where the state can maybe assist or our CROG can maybe assist. Resale of affordable units is somewhat of a challenge because it is a moving target, what they can sell for. And a lot of them that were sold in Clark Estates were sold for a certain amount because the interest rates were low. You know, you can't sell them for that today. So it's really a challenge, these affordable units that are for sale. So just something to keep in mind as we move forward. It is something that, you know, we get these affordable housing plans that they file, but it comes back on the town as far as the administrator moving forward.
You got time.
Yeah.
Quick, no, one more quick thing, I don't wanna take up a lot of time. But on a couple of these subdivisions that we have received recently, if there's a subdivision that's 5 units and under, there does not have to be an affordable component, but there is a monetary, the 12,500?
So what there is once you're creating 3 new building lots, there is a formula that you have to apply, and it's based on the zone you're in, and it's based on the number of lots, and based on the cost of housing. So it's a formula, it's in your subdivision regulations. And the most recent one that we applied it to was the Casarino subdivision, and it came out to about $17,000 a lot. And it's modeled the same way that your fee in lieu of open space is modeled. If you recall, if you know you have a subdivision and they're not gonna give you open space, there's a process by which you can collect a fee. And that's either paid 100% right up front, or it's paid at the time of the CO of each unit. So we track that. So just to give you an example, if this Casarino were to go into construction, they would either pay us the amount that's been determined through this formula, so it's determined at the time of the approval, or they would pay us 1/3 of that as each CO were issued as part of the fee.
Yeah, cause
So-
I think when Johnny Jakes is one there. with
John's
the
would do that, so that's only
Caruso's.
subdivisions, right? Because in any of the other kinds of housing that we do, which is multifamily, we're doing deed restricted units through a percentage.
Correct, that's for the affordable
So
housing,
that's
for
10%
our,
or 15% units.
I guess to go back to, where does that money go?
So the money goes into, the town adopted a Fair Rent and Housing Committee commission 2 years ago, which we had to do a fair rent commission by law. The Housing Committee, if you recall, when we did an affordable housing plan, one of the recommendations was that we form a housing committee for affordable housing. So part of the role of this Fair Rent and Housing Committee is that we have a housing trust fund. So the money that's collected will go into the town's housing trust fund, and that money will be used to support potentially like the housing authority money for design or something like that. Or maybe if you got enough of a nonprofit coming in and using some, you know, applying for some money to use for an affordable project that they're doing. So the idea with these housing trust funds, what towns are doing with them, are creating a pot of money that can later be used to create more affordable units in their town. We might use it to buy a deed restriction to 40-year deed restricted property affordable. But you can't do anything till you get money, right? So the housing trust fund has been set up. There's a mechanism in the housing committee as to who's gonna, you know, I don't wanna say control it, but advise on it. And we just have to start putting it. And I use an analogy of our open space fund because we used close to $300,000 to make the Mitchell Fairgrounds. And that was all money that this commission collected over 30 years through the fee in lieu of open space. I know people don't really know that.
Mhm.
It wasn't, you know, a capital project or anything like that. That was all fee in lieu of open space money. So I'm a believer in these funds because eventually they can, you know, have meaning.
What happens, the restricted covenant on the fair housing is 30 years?
No. And deed restricted units affordable, it's typically 40 years.
40 years.
Yeah, and that's what we have in all of our regulations. So what we did when we did our moratorium on housing, we came back and we adopted inclusionary zoning for the newer members. Inclusionary zoning is a requirement of an affordability with every housing project that goes forward, so.
After 40 years, then it's fair
Then
market.
hopefully you're gonna renegotiate the affordability on it. I don't know, I'm not gonna be around, so you gotta tell me what happens.
I won't either.
Although, you know, we say won't be around, we're probably getting on 25 years on our berry patch, right? That's been around 25, almost 30 years. So these aren't things that are like so far off distance that you don't have to think about.
Is there a way to look into some housing and stuff in town to classify as affordable? You know, like they were
Unfortunately,
talking, I think, on like trailer parks or.
There is a way that
Is
you
there a very
could
much?
do it, but it's, you know, they would have to deed restrict it, so the owner of the trailer park would have to be willing to deed restrict
To deed
it.
restrict.
We did have that
All those
conversation when
would pretty
someone
much
was
fall
looking
into that category of affordable in town.
Yeah, you know,
It really wouldn't be.
planners have always tried to make the argument, it's accessory units that you put in, you know, they're affordable, but they don't get to count. So, you know, the state has really defined very specifically what they consider an affordable unit, and until that definition really changes, you're kind of stuck with what you're stuck with. But we've done good things in that, and, you know, regarding affordability, we have a lot coming online when projects do come into construction. So, you know, I look at the law and it looks at like, you know, you have to, you know, put where your policies are and what your practices are. I mean, we've put a lot of zoning in place towards affordability. We haven't put the densities in that I think that they're looking for, but, you know, that's for another discussion. The other thing that it looks like the law is looking for is they're looking for what kind of policies are you as a town gonna have, like, what kind of abatements are you gonna give, or what, are you gonna waive building fees for affordable units, or, you know, what kind of incentives or other kinds of things can you do as a community to make these units happen? So that's part of what, you know, I think that we can start documenting and start looking at, you know, it's a year and a half before you're gonna have to really come up with anything solid on this, but there's stuff that you can start looking at and, you know, codifying that we've been doing right along, so. So that's kind of what I just want to show you on the general planning discussion. And the other thing that I wanted to just to throw out there is, you know, I always look at our plan of conservation and development as kind of our work program. So I would just encourage people to go through the back of it where we have, you know, kind of the things that we said that we want to try to accomplish or think about accomplishing. And if there's specific things that you want Justin and I to work on, or there's specific zoning topics out there that you want us to do more research on or craft regulations around. One of the things that we didn't do over the last 2 years that we talked about was short-term rentals. And I still think that may be something that we wanna come up with some regulation around short-term rentals, because short of a regulation, they're allowed. So that may be something that you look at with the town council too, because it probably would be better as a zoning regulation and a town ordinance, so you have some enforcement or some teeth behind it. That's just one of the ones that I think of. So I just would turn it back to you, Paul, but those were just.
I do recall that we said no to, Airbnb.
Yeah, you had a text amendment that you denied, right? But I think at the time, the discussion was that maybe we would allow it, but we wanted to put some kind of rules around it and have a town ordinance possibly around it for licensing, if you will, maybe, of them.
Bonds?
Josh, did you give us a list of bonds? Should have one.
We have bonds. All right. Thank you. Does someone want to go through the bonds?
Took my copy.
I can read it if you want.
Strategic.
I would love it if you did.
All right. 21-47P, Revolutions Multi-Purpose Field. Amount 10,000, reduction 5,000, balance 5,000. 21-39P, Kilkenny Heights 2, E&S. Amount 5,000, reduction 5,000, balance 0.
Hold on. Refresh my, we approve each one individually.
You can do a whole group of them at once.
No, we can
That's fine.
pull.
All right.
Yep.
I'm sorry, keep going.
24-42P, Aldi Parking Lot Expansion, E&S, 15,000, reduction 10, balance 5. 24-42P, Aldi Parking Lot Expansion, Stormwater, amount 10,000, reduction 10,000, balance 0. 11-24P, EW Lifestyle Mitigation, amount 10,000, reduction 10,000, balance 0. 11-24P, EW Lifestyle -ENS, 25,000, reduction 25,000, balance 0. 22-36P, Prime Material ENS, amount 5,000, reduction 5,000, balance 0. 22-36P, prime material, stormwater, amount 20,000, reduction 15, balance 5.
And landscaping bonds?
Landscaping bonds, 21-6P, Evergreen Walk, 7C, amount 5,000, reduction 5, balance 0. 19-08P, Redwood Brick, amount 10,000, reduction 10,000, balance 0. 11-28P, Hanoush Jewelers, 4,000, reduction 4,000, balance 0. 22-22P, Hartford Truck Berm, amount 5,000, reduction 5,000, balance 0.
Motion?
Second.
Do I have a motion?
Motion
So
to
moved.
approve the, all the bonds.
Second.
Say aye.
Aye.
Any nay? Passes. Any old business?
No, I just would let you know that you have a public hearing next week, and we have a couple preliminary discussions next week, and we do have an application that you're officially receiving, the Downies, which is the zone change request.
Let's see that.
We do have a packet of information back here that we're gonna send you home with, which is a market study, traffic study, a whole bunch of stuff. We're slating that for a January public hearing, so the second Tuesday in January. And then you do see that we did receive just yesterday the Gateway, which is the project that's under construction right on Buckland Road here. If you recall, they had 2 buildings in the front that were retail buildings. They're gonna take those 2 buildings and break them up into 4 smaller buildings. So, they have a new design to the architectural, so that is going through design review, and we'll try to get that on our December meeting as a site plan modification for December. So that's kinda all we got pending right now. Moving forward.
Anything else? Motion to adjourn?
Make a motion to adjourn.
All in favor?
Aye.
Thank you all.